Thank you so much. So you're going to listen to a lawyer. I know you're so excited. We're going to try to make privacy and information sharing interesting. So I want to answer 4 questions today. When do we need consent for information sharing? How does capacity arise when we're dealing with brain injury services and information sharing? Who makes decisions for a survivor or a client? And then how do we involve caregivers when the survivors or the client want them involved, but what happens if they don't want them involved? Can information still be shared? So I'm going to start off with, when do we need consent for information sharing? So consent is the act of giving permission for something, and this something is sharing information. So this talk is all about privacy. And when we're talking about privacy, we're talking about 3 different actions. We're talking about collecting information. That is when the brain injury service or the hospital or the long-term care home or the community support service or the home care service is taking information from the survivor client or receiving that information from someone else. And that someone else might be a caregiver, it might be another healthcare provider, it might be other third parties that are sharing information. So that's when we gather information in, that is collection. Then we have to have permission to use information within a brain injury service organization, and that's when we share information within a team. To disclose is when the brain injury service or organization is sharing information to someone outside, and that might be to disclose to a family member, to an insurance company, to another healthcare provider. So consent. We need consent to share information with healthcare providers, but I'm going to talk a little bit about implied consent and something that you may have heard about, the circle of care. Dun, dun, dun. So I want to explain to you what that is and what it is not, because there's a lot of mythology about that. Okay, we also need consent to share information with insurance companies, with lawyers, with employers, with schools. We also need consent to share information with family members of the survivors. So here we are going to talk about the circle of care. What is it? What is it not? When does it start? When does it end? So in privacy, there is this concept of the circle of care, but it is not written in the law. So there is no phrase circle of care in our provincial law, which is called the Personal Health Information Protection Act. So we have to read between the lines, but this is a concept that we want to make it easy for healthcare providers to share information with each other in order to have coordinated care, continuity of care. That's the idea. So the circle of care is on a continuum with a lockbox or a consent directive. So I'm going to share what both of those things mean. Here we have the circle of care, and here we have a lockbox. So the circle of care, healthcare providers are allowed to assume that the people that receive services from them want other healthcare providers to receive information. We're allowed to assume that. So the idea is that there isn't a barrier for sharing information between healthcare providers in order to provide healthcare services. Oh, like, wouldn't that be amazing if we actually had a coordinated healthcare system? Yes, it would. But we don't exactly have that, but that's what the law allows us to do. So on the other end of the spectrum, there are situations when survivors, clients, do not want their information shared with their other healthcare providers for a particular reason. So individuals are allowed to come forward and say, no, I do not want you to share certain information or any information with my other healthcare providers. And when that happens, the healthcare organization has to put in place a limit so that they no longer share information with other healthcare providers. So circle of care, and then we have lockbox, also known as a consent directive. So when we're talking about the circle of care, there's a who and a why, and both of those parts have to exist together for the circle of care to work. So who can be in the circle of care is any healthcare provider. So you have to be a healthcare provider to be the who, and then the why is only to provide healthcare, not for teaching, not for research, not for planning programs, not for fixing the healthcare system, only to provide healthcare. So a who and a why. And when we have the who and a why, we're allowed to assume that we can share information. So I want you to have a little look at this list based on what I just told you, and just think to yourselves, who on this list can be in the circle of care? An employer, a hospital, an insurance company, the client's sister, a landlord, the police, a primary healthcare team, the Workplace Safety and Insurance Board, or Brain Injury Services. If you thought it through, here's the answer. So here's who's in and here's who's out. The hospital, the primary care team, and the brain injury services can be in the circle of care. What are they doing? Assuming implied consent, they can share information. Who's out? The employer, the insurance company, the client's sister, the landlord, police, and the Workplace Safety and Insurance Board. Do not feel too badly for the right-hand side, because we can always share information with them with express consent, or if we are permitted or required by law. So there will be situations where those sharing of information has to happen. But the circle of care, again, just greasing of the wheels to make it easier to provide health care. So here's the longer list of who can be in the circle of care. So for brain injury services, as survivors, you may be receiving services from all kinds of different providers. Your doctor, you might see a social worker, you might see a dietitian, they might each have their own practice. They will be their own health information custodians. They are in the circle of care. If you receive services from a brain injury service organization, they are likely to be found under that community health or mental health center program or service. If you live in a residential facility or supportive housing, they are also in the circle of care. If you're in a home for special care, the people who are delivering community support services and home care services, they're all in the circle of care. So the idea is also hospitals, right? Ambulances are all in the circle of care. The idea is that it's all the traditional providers of healthcare services can assume that the people who are receiving services want their services to be coordinated. So who's out? Insurance companies, employers, family members, teachers, and schools. But if you are working with children, there are some healthcare providers that work within school boards. So social workers, speech language pathologists, occupational therapists, physical therapists, and the psychologists of school boards are in the circle of care. Prayer and spiritual healers and leaders are not. Landlords generally are not in the circle of care, but if someone is in a retirement home, they're in. If they're in a long-term care home, they're in. If someone is receiving services from a supportive housing agency, they are in. A children's aid society is not in. The police are not, and then government institutions are not in the circle of care. So we don't assume that we can share information with government because they're not delivering direct health care. Make sense? Who? Direct healthcare providers. Why? To provide healthcare services. So how do you know if someone is working within a healthcare organization, how do you know you're allowed to share your client's information with their other healthcare providers? You're allowed to assume it. So please do. Now, we had a presentation earlier about some of the limitations that really exist, especially at transitions of healthcare. So when people are in a hospital and they're moving into other healthcare environments, there is often a lack of information shared. Those discharge summaries that we were hearing about earlier. That has nothing really to do about privacy as much as it has to do with resourcing. That we don't have a lot of staff at those moments of transition who are writing out the summaries and giving the next service providers their list of instructions how to support that person in their next community environments. The law allows it, but we don't have a lot of resourcing. So you will see sometimes people have super awesome transitions because clinicians had the time and ability to write out instructions, or they did coordinated care planning. And so when somebody goes through their care journey, there is information. But oftentimes, it isn't a privacy issue why that information isn't available. It's just that nobody wrote that information. So we can absolutely assume to share information, and I would highly encourage healthcare providers to share information. Now, the circle of care is not no consent. So there are situations where a survivor will say, I don't want information shared with my primary care team. I saw that psychologist, I don't want to see them anymore. I don't want you sharing information with them any longer. So the circle of care allows healthcare organizations to assume that they can share. But as soon as a client says, no, I don't want you to share, now you can no longer share relying on implied consent. To share at all, you would have to get the express consent of the survivor. And you would always have to ask, and then if they have asked for a lockbox or a consent directive, or if they've said no, they may continue to say no ongoing. So that's allowed. So it's not, the circle of care isn't, hey, all the healthcare providers get to share information however they like. They get to assume that's what the client wants, but if they know the client doesn't want it, they cannot share information. So this is very much survivor-led. It's just we assume that people want their information shared first, unless they tell us otherwise. So this whole idea about the circle of care is what underpins the whole context of Ontario health teams. And many of you will have heard about Ontario health teams. They came out in 2019. They've really been only going for a few years. In the Ottawa region, you have at least 3 that are serving different parts of the Ottawa and greater area. And they are geographic groups of healthcare providers that are working together, again, to provide coordinated healthcare within a geographic region. So the circle of care is what underpins and gives authority for those organizations to work together. Now, for survivors, you are entitled to know about Ontario health teams. So wherever you are receiving services, there should be notices, there should be orientation pamphlets, there should be posters, there should be things available on organizational websites to explain how those organizations work together. Now, it's in everybody's interest, especially for survivors, that your organizations work together, again, Do you need to hear me sing it? It's because if we can have that coordinated care, then there can be better outcomes. Right now, you would think, since it is 2024, that we would have integrated health records, but we do not. So everywhere you go, and you know this better than me, that everywhere you go, you have to retell your story. You may have to replace some of your information because the next healthcare provider does not have all of the backstory. So this idea of an Ontario Health Team is getting us towards a space where we have more coordinated information, and the law allows us to do that. Now, the other thing that we are looking for, and this is what the government has told the healthcare system, is that when these Ontario Health Teams reach maturity, we will have the integrated health record where somebody, and as you're on your journey, as your healthcare providers contribute to your health record, all of your other healthcare providers will be able to see your health journey and be able to get the information they need in order to better serve you. That does not exist yet, but that's one of the goals. Now, another thing that you as survivors should be advocating for are client portals. So depending where you receive services now, you may be able to see the health records that your care providers make about you instantly. And that's a real benefit for many of you who have complex health journeys, who need to be, again, able to share your health records in many environments, because if you and your caregivers and support system can have instant access to your health records, you can then share those records any place you go to receive care. This also helps you travel, right? Because if you happen to be in another province, if you happen to be in another country, but you can access your health records in a portal, and something happens when you are out of country, you can get your health records. So this is one of the things that our government is really moving towards. And it is a right, not a preference, that survivors get access to their information. So if you are a survivor, it is your right to have a copy of all of your health records. All you have to do is ask. Now, a client portal is a free, usually, version of getting your health records. Right now, we still have a lot of charging for health records, and that is permitted. Organizations are allowed to charge for giving you access to your health records. So I also wanted to talk about the situations where consent is not required, where we do not ask survivors for their permission to share their information. So in law, the phrase permitted or required by law, that's what you will get. You'll hear that. So there are two umbrella categories where we do not ask for survivor consent to look at or share their information. And the first one is for safety and protection, and the other one is for the functioning of the healthcare system. So there are some situations where survivor permission is not sought to share information. So permitted by law is when a brain injury service organization or the hospital is allowed to use survivor information without the consent of the survivor. For example, they can do that to plan their programs. How many people who are receiving services from us are also smokers? Maybe we should think about having a smoking cessation program to complement the other services that we're offering. The organization is allowed to look at that information without asking for client permission to do so. Now, there's another big category when safety trumps privacy. So this is when there is a significant risk of serious bodily harm to the survivor or to anyone else. So there, as one of the previous slides had said, there can be rare situations of intimate partner violence. But if there is a situation where a healthcare provider believes that their client is at risk of hurting their intimate partner and sharing that information would reduce that risk, than we share with no consent. So that safety issue of saving a life will override otherwise a privacy obligation. So there are also situations where healthcare organizations are required by law to either take in information, use it, or share it. And when that happens, we don't get survivor consent either. So here are some examples of that. Healthcare organizations will be required to disclose under laws to deal with a child in need of protection, someone under the age of 16 who has been or is at risk of sexual, physical, or emotional harm. That is a mandatory report to a Children's Aid Society or an Indigenous child well-being agency. Public health. So if someone has a communicable disease, that is a mandatory report to the public health and to the medical officer of health. Transportation safety. If someone is unfit to drive, their doctor, their nurse practitioner, or their, the eye doctor, optometrist has an obligation to, that's optometrist, I think, has an obligation to report to the Ministry of Transportation. If someone is unfit to drive, unfit to steward a ship, unfit to fly a plane, those are mandatory reports to the Ministry of Transportation because that's a public safety issue. There are also mandatory reports to regulatory colleges, and so information sharing with the College of Psychologists or the College of Nurses. They do an overview and they regulate those professions. They get information in order to do so. That is done without the consent of clients. If there is a suspicious death, that has to be reported to the coroner. And also, the Workplace Safety and Insurance Board does have mandatory reporting under certain circumstances, so sometimes records have to go to the WSIB. For healthcare organizations, if an authority is saying you must disclose health records, it's very important to get that you must in writing, because that then gets put as part of the client's chart, and that is an explanation why the organization went into the record and why that information was disclosed and to whom. There may also be other situations where an organization is required to disclose information because they got a court order. So it could be in the case of separated parents that certain information is required to be shared between them when there is a custody issue, and that would be done through a court order. It's also required for healthcare providers to go to court and answer questions. That can be done through a summons to witness. They might get a subpoena. They might receive a warrant to review the health records that they have. And also there's a new thing since 2019 called an urgent demand for records. So the government was finding that it was really difficult to support people who went missing because most organizations wouldn't share information. So back in 2019, the government gave police officers further power to compel organizations like any kind of home or any kind of healthcare provider to release information in the case of a missing person. And the document that a police officer gives in that case is called an urgent demand for records. And so then if you get one of those, you have to respond. So a couple other things. How does capacity arise when we're talking about brain injury services? There is a legal test to make decisions for yourself, and that test is presumed. We presume everybody is capable to make their own decisions. So that is where we start. Everyone is allowed to make their own decisions unless it's unreasonable to presume someone is capable. Some people might be making some of their decisions, but not all of their own decisions. Some people can have fluctuating capacity. Age does not determine capacity. You can have 12 and 13-year-olds who are making their own decisions. You can have people in their 90s making their own decisions. And diagnosis does not determine capacity. Just because someone has an acquired brain injury does not mean they are incapable. If someone is incapable, they need a substitute decision maker. So when you're in a healthcare environment, the people providing the healthcare service are, if it is suspicious that someone might not be capable, they are assessing where someone's capable. And the test is two parts. A person is capable if they have the ability to understand the information that is relevant to making the privacy decision, and also are able to appreciate the reasonably foreseeable consequences of saying yes or no. So two parts to the test. So we evaluate capacity when someone has a mild or moderate brain injury. If it's an extreme brain injury, it's unlikely that a capacity assessment needs to be done. If the client does not appear to understand decisions or is confused or irrational, a capacity test would be applied. If the individual has just regained consciousness, if there is a mild or moderate intellectual or developmental limitation, usually between the ages of 10 and 15, people will become capable, and we have to assess whether they are or are not for certain decisions. And if a clinician is just unsure of someone's capacity, then a capacity assessment will be made. But these are not circumstances when capacity has to be assessed. If an organization does a poor job explaining something, somebody might not understand, but that's not because they're incapable, it's because the organization did a bad job explaining it. Or if somebody doesn't speak English or French and they haven't been given an interpreter. If they need assistance to communicate due to an impairment and they need someone to assist them to communicate. If they have a religious or cultural barrier to participating in their decision. If they're just or shy, they haven't said anything, that does not make them incapable. If they need extra time to make their decision, if they would like to talk to someone or make a consultation first. And here's another one. Just because a survivor does not agree with the care plan does not make them incapable. Now, it might mean that the clinician wants to talk to them and they might want to assess capacity, but just disagreeing does not make someone incapable. So who makes decisions, privacy decisions for a client? If someone is capable, they make their own decisions. If they're incapable, they need a substitute decision maker. So it does happen all the time that families and clinicians ignore when a client is capable because the family or the clinician are loud. And it's just, we just kind of roll over and say, oh yeah, that person, their family member is just really engaged and they're the ones making the choice. Except if the client is capable, it's the client that has to make the choice. Now we can engage the family, absolutely, but the client has to make their own decisions. But if someone is incapable, the law gives us a list of who's going to make the decisions for the client. And it is a hierarchical list. So it starts at number 1 and it goes down to number 9, and we're just looking for someone who fills the description. So on the left-hand side are people who got that position because a legal process was engaged. Number 1, a guardian of the person. How would you know? There's a document for that. Someone went to court to become a guardian of the person. Number 2, someone who holds a document called a power of attorney. Have you heard about that? Yeah. Does everybody misunderstand that? They sure do. And there are different ones. There are financial powers of attorney and there are personal care powers of attorney. Number 3, someone can go to the Consent and Capacity Board and become a personal representative. Very few people do that. It is an awesome process because if you go to the right-hand side, these are the people who automatically populate. But let's just imagine that there's conflict between one of the categories. So for example, brother or sisters or siblings of the client and they don't get along, they all have to agree because they're in the same category. So one of them could go to the Consent Capacity Board to become a number 3 and trump all their family members. So Nobody does this, very few people do it, but that is a possibility. So on the right-hand side, who is the automatic family list? A spouse or a partner. Under that, the children of the client or the parents of the client. And then if the Children's Aid Society, if you're dealing with kids, if they are in the care and custody of Children's Aid makes decisions. Then a brother or a sister or a sibling of the client. Now, then we're looking for any other relative. Notice on this list is not a roommate, a friend, a nice person in the community, or someone who supports the survivor. Okay, it has to be a family member. If there's no one who meets the test who's on that list, the public guardian and trustee is going to make healthcare decisions and also privacy decisions. Substitute decision makers themselves have to be capable with respect to the treatment or the privacy decision. They have to be at least 16 years old. They have to not have a court order saying they can't be near the survivor or the client. They have to be available. They also have to be willing. So you can't make someone be a substitute decision maker, although guilt does go a long way. So if we look at a scenario, if you have a client's new romantic partner has told you he is going to make decisions for the client, and he has instructed the brain injury service not to involve the client's family anymore, who do we go to? We should ask the client first, if the client is capable, what they want. If they want their family involved and their new romantic partner, great, we can involve everybody. If they're incapable, we need to find who is the decision maker, and we need to know who is a spouse or partner. This is a new romantic partner. Do they meet the test? A spouse has a definition. It means someone who is married to each other. They live together in a conjugal relationship outside of marriage, and they have lived together for at least a year. If they are together the parents of a child, or if they have entered into a very romantic cohabitation agreement, they are also spouses, unless they live separate and apart as a result of a breakdown of the relationship. A partner is much broader. So a partner means either of two persons who have lived together for at least a year and who have a close personal relationship that is of primary importance in both persons' lives. So a new romantic partner, unless they've been together for a year, is not going to meet the definition. And so we would be looking for, if they're incapable, we'd look to see, is there a legal document that exists? And otherwise, is there another spouse or partner who's available? And otherwise, the children or the parents of the client, or then we'll look for other relatives. If there are multiple people in a category, you don't have to canvass everybody in the category. You can, as long as you don't think that other people object, you're allowed to proceed. This kind of thing happens mostly with children and parents who are dueling. Then it has happened occasionally that one parent says, don't share information with the other parent. And if you get that instruction, now you can't share information with the other parent. Two dueling substitute decision makers can cancel each other out. Is this complicated? Yeah. Is the organization going to get some advice? Yeah. Are they going to try to cajole the parents to get along for the benefit of their child? Yeah. But that's what happens. It can become a bit messy. And then finally, how do we involve caregivers, and what happens if a client or a survivor doesn't want their caregivers involved? My message to all healthcare providers is we must be proactively asking clients who supports them. With whom do you want us to share your information? How do we create supports around you? We've just talked a lot today about social isolation. Social isolation kills people. So we need to presume that people live in community. We need to ask people, how can we support you, and how do we get information into the hands of the people that support you? So we need to presume that clients have family and support people. We need to ask who they are. We need to make suggestions as healthcare providers. Hey, why don't I tell your sister about how you're doing? Hi, Why don't I keep your kids up to date and tell them how to look after you and how to look out for warning signs that you may be deteriorating? These are good things. And then in healthcare, we need to document those conversations for the rest of the team. In 2021, I wrote some resources for the Ontario Caregiver Organization. These are available for caregivers. These are the people who are supporting the survivors. These are friends, family members, people in the community. But also these resources are available for care providers, the clinicians. And there's a big long document and then shorter documents. And then there are Q's and A's. And there are special ones for kids. There are special ones for mental health. There are special ones for people who are capable to make their own decisions, and special ones for people who are not capable to make their own decisions. And they come in French, so it's good. And the other thing just to talk about when we are thinking about sharing information with caregivers. What happens when we talk about privacy is everybody presumes that privacy is an on-off switch. Everything, nothing. And that's not what we need to be thinking about. When we're thinking about sharing information, we need to be thinking about what information does a caregiver need? Maybe a little bit of information. So sometimes clients say, no, I don't want my brother to know anything. Well, can we tell your brother that you're getting services, that you are supported, that here are the ways to look out for you? Yeah, fine, I can live with that. I don't want him to know all the details of my sexuality, as we talked about earlier. I don't want him to know about the ways that I'm struggling. And so you negotiate as care providers. That is really easy. You know, the privacy conversation is easy when we have clients and families who are coming in, receiving services, and they share everything. It's also easy if a client is incapable and the substitute decision maker is aligned with the care plan and keeps the client up to date and other family members up to date. It's also easy if the client is hovering between capacity and incapacity but wants their family involved. On the other side, it's hard, but at least it's clear that we don't share information if the family is posing a threat to the client. If the family have no interest in the client or they're estranged. If the client is incapable and there is no family involved and the public guardian and trustee is involved, we just share information with them. It is hard, but it's also clear if the client is threatening harm to themselves or others, that information is going to be shared to protect. Where it's challenging in this yellow requiring a nuanced approach is when the client doesn't want their family involved, but the family do want to be involved. When substitute decision makers disagree or they won't keep each other updated. If the client is okay to keep one family member in the loop, but not everybody. If the client is doing suboptimal self-care, but not at the level of a threat, and it's a step down from an emergency, that can be hard. If the client is incapable, but doesn't want what the substitute decision maker is agreeing to. So that was my whirlwind of privacy, consent, information sharing, and my takeaway message for all of the clinicians in the room is presume consent to share information with other healthcare providers. That is how we do not miss people through transitions and that we can have better outcomes. Thank you.